Good evening, everyone. So tonight, I'm giving you the opportunity to bring up questions or issues which are bothering you as you prepare towards this examination. So you have the opportunity to either speak or you use the chat so that we deal with your questions. And don't feel shy to speak because you are learning separately and you are the best judge of things that you are having challenges with. Maybe topic A, one person might have studied it very well, and that may be an area bothering you. And for that matter, when we create a platform like this, we hope that you will take advantage and bring up issues bothering you so that we discuss them together. Yeah, so if you are so minded to bring up any issue, I will listen and then we discuss it. So we are doing basically questions and answers.
Good evening, my lord.
Good evening.
Please, I would like us to run through easement and the land law.
What? Easement?
Yes, please.
Easement, okay.
That's a recap of it.
So is there any particular aspect of easement which is bothering you?
What I studied it and then I went for discussion somewhere and in fact I got a little bit more confused. So I want to get it straight away.
Okay, all right. All right, okay, thank you. Easement. Any other, or let's finish with the question about the easement before we move on to discuss some other things. Okay, so to start with, one useful material I will direct you to, of course, there are two materials, essentially, Mr. Darucha and Lodo's book. That's a Ghana landlord conveyancing in Ghana. If you look at chapter, let me get a chapter number for you. Yeah, that is chapter 10. If you look at the chapter 10, it's a very well treated. And of course, you also look at the Sir Dennis's book, that is Landlord Practicing Conveyancing in Ghana, chapter 14. He has also treated it very well. So the point to remember is that first and foremost, when we mention easements, we often associate it with what we also call the profit apron. So just as we mentioned, tenancy in common, and then we add, let's say, joint tenants, and then we explain the two together. It is also common to see easements and then profits apron being mentioned together. So these are lesser interests in land. And what are they? Easements is an interest or right recognized by common law as pertaining or attaching to a particular land, and it allows the holder of the easement, that is the proprietor, to be able to use the land to which the easement is attached in a way which will have been trespass if you have not been for the easement. And let me give you a very simple example. So let's suppose that you have a land, let's call the Black Acre, right? Black Acre or Blackberry X, a parcel of land called Blackberry or Black Acre X. And there is another land adjoining it called the Black Acre or Blackberry Y. And then next to the Y, we have Z. So you have, let's say, 3 lines in succession, S, Y, Z. Now, let's suppose that the person who has the person on the, let's say, the X, which is like the first one, let's assume that he acquires the land, let's say, called Z. The Z, that is the third one. And let's suppose that for a long period of time, a footpath is created through, let's say, the middle land, Y. And the original owner of Z used to use the footpath through the middle land to get to his land and all that. Now, because for a very long time, the common law, the law has recognized that footpath runs through the land which belongs to another person to enable the one on the Z to be able to get there. That right or that interest runs with the land. And for that matter, if the one who has the Z should, let's say, that walk through the middle one in order to be able to get to his land or do any other thing, it will not be considered as interfering with the middle one, it will not be trespassing, because it is the law which has recognized it. So let's keep that in mind. So it's usually either right of passage, right? Right of passage, you can pass through somebody's land to be able to get to your land, or it can be in respect of even light. Maybe a light may have to pass through your land in order that somebody will be able to also access the light. Yeah, so that is the easement. Unlike the prophet apron, which is the right recognized by the law that you can go to another, somebody's land and take fruits, like the profits, maybe like the fruits or things which are on that land. So you are just going to take something. So that's the profit. But easement is not you going to take anything from another person's land, but you are just making use of the land in a certain way so that you are able to also enjoy your land as it were. But as I said, without the right which is attached to the particular piece of land, which allows the owner of that land to be able to use or restrict it and all that, it will have given rise to trespass if you actually pass through it. But because of the easement, if you make use of it in the manner as secured by the easement, you are not committing trespass as it were. Now in Ghana, if you look at the very first time, if you look at the PNDC 152, when it talks about the range of interests which are recognized under our law. It includes easements and then the profit upon, and the same idea is carried into the Land Act of 2020. But we must understand certain important features of easements. First of all, before we can say that an easement exists, we must have two types of, if you like, land. How do you call the dominant tenements? That is the dominant land, if you like, and then the servient tenements, or the servient land. And secondly, we must have the dominant tenement, the dominant land must accommodate the right, which we call like the easement. We explain each of them pretty soon. And again, the dominant and then the servient tenements must not be both owned and possessed by the same person. If the two lands, right, the dominant one and then the servient one, if they are possessed by the same person, then we cannot have easement, because the title belongs to one and the same. So if you have the title to something, how could they give rise to trespass if you have to make use of it? So that would be conceptually inadequate. And that is why the two lands, that is the major land, what you call it, the dominant tenement, and then if you like the servient tenement, that is the minor land, in respect of which the easement will be claimed, should belong to two separate persons or entities, as it were. And again, the easement must be a right which lie in grant. That is to say that it must be capable of forming the subject matter of a grant. If you say like a grant, that is, you are making a grant, you are selling the land, you are making a gift of it, creating a lease of it, and so on and so forth. All these are various ways of making a grant. So we have said that to have easement, you need dominant and then servient tenement. What is the dominant tenement, and then what is the servient tenement? That is to say that one enjoys the benefit and the other which carries the burden of the easement. So the dominant tenement enjoys what we call like the easement, and the land against which the easement is exercised or is asserted is called the servient tenement. So that is carrying like the burden. So for example, if you are using someone's land as a footpath, as it were, as a very convenient example, the land through which a footpath is accessed will be like, if you like, the servient tenement, because it's carrying the burden of what? The easement. And then when you use a footpath, you reach another land. So the land which you need to use like the footpath to reach, that will be like the dominant tenement, because it is that land which is enjoying the easement. The easement is, if you like, the footpath through that particular land. So you use it not because you want to be on that land. You're using it because you want to reach your land, the dominant tenement. So let us keep that in mind. That we also said that the right must accommodate the dominant tenement. And what do we mean by that? That is to say that an easement must not only be pertinent to a dominant tenement, but it must also be connected with the normal enjoyment of that tenement. What is that? That is to say that if, for example, you have the situation which happened in the case of Ackroyd and Smith. In the case of Ackroyd and Smith, the point was made that a right of way, like maybe like a footpath that I've mentioned, was granted for all purposes to the tenant of Blackberry and his successors in title was not an easement, for the grant permitted the way to be used for purposes not connected with Blackberry. Good. Now, what that means is that the particular thing which we are going to, or the law is recognizing as easement, must have some kind of like a specificity, if you like. If the land is like a right of way to and everywhere, and not to any particular, let's say, parcel of land, then we cannot talk of it as being easement, because the easement must be referable to a particular, if you like, a parcel of land. That is why you talk about like the dominant tenement and then the servient tenement. So that specificity and being referable is very important. So therefore, if you say that, let me use a typical example. Let's say that you take Adenta, right? I'm using like the main road. You take this like the Adenta, and then you take the Zongo junction. And let's say that you take if the understanding is that to get to atomic junction, let's assume that is somebody's land. Peter, please put off your mic. Peter, put off your mic. Thank you. Yeah, so if the understanding is that to get to atomic junction, let's say that is somebody's land, you must necessarily go through the Zongo junction, otherwise you don't get there. And that is quite specific. But if we are not talking in reference to, let's say, atomic junction, and we are talking like in general, that you must go through, let's say that Zongo junction to be able to get to anywhere, then we are not talking about easement, because the characteristic or the feature that the right must accommodate the dominant tenement will be lacking. You cannot just have general thing, and that is why in the case of Ackroyd and Smith, the court said that what was at stake was not easement, properly so-called, because it was the particular easement created was not referable to purposes connected with the particular black acre. That is like the dominant tenement. And just in case of just journal, we're saying that we need two lands: the servient tenement, that which carries the burden of the easement, and then the dominant tenement, that which enjoys the easement. And these two must also not be vested in the same person. Otherwise, that will be conceptually impossible. So the dominant and then the servant owners must be different. So one must own one must have title to the land against which the easement is going to be exercised. And then a different person must have title to the land in respect of which easement must be enjoyed against another land, so that that particular land can be assessed. And the land which is enjoying the easement, as we've said, like the dominant one, and then the one against which is being exercised is the servant. Then these two must belong to different owners. So there's also the need for specificity when it comes to the description, right? Because you said that the right must be capable of forming subject matter of a grant. You should be able to grant easement, just as you can grant any interest in land. And if that is the case, there's a need for us to be able to describe it with certainty. And that there's also the need to have a grantee. And because there's a need to have a grantee, that is why we said that the dominant tenement and then the servient tenement must have different owners. Because if it belongs to the same owner, then it will not actually make sense conceptually. Yeah, so these are some of the things that we should keep in mind when we are talking about easement. And then we can look at the examples. We've mentioned the footpath, that is like the right of way. Also light, like the sunlight or even normal light flowing over an adjoining light is also an easement. So therefore, if let's say that for a long time, the light passes through passes over your, let's say maybe your house, for me to get light in my adjoining house, then you cannot just build to block that light. Because if you are to do that, you are interfering with the easement, which my land enjoys against your land, which is like the servient tenement. Of course, rights in connection with water can also be easement. Let's suppose that you have like you need to run, let's say, the water through somebody's land, either irrigation purpose or some others. Otherwise, the land cannot get to your own farm or to your own land. In that case, easement may also exist as it will. So let us keep that in mind. Well, we can, as for the example, we can keep extending them, and we will not even exhaust it as it will. Especially now that we have drones, right? You have somebody's drone flying over your house so that it can take a good area view or picture of its own house. That may also be an example of an easement, because he can probably not take a good area photography of his own house unless he enters into an airspace above your own roof or your own building, as it were. So let us keep that in mind. And we are not doing conveyancing yet, but it is important to remember that easement may be acquired in various ways. Either there may be an express grant, that is just as somebody can acquire, let's say, a lease. In the same vein, you can also acquire it. Or when you are acquiring a particular interest in land, there may also be a reservation, which is made, or an implied grant, which is made. And that will also enable the easement to come into being. Then we also have what they call like the easement of necessity. That may arise where you look at the circumstances of a particular land in relation to another. It will be such that the grantor is cut off completely for some part of his own land. Otherwise, another person cannot enjoy the land. So out of necessity, easement may also arise. But as I said, at this stage, because you're not doing like the conveyancing, all that you need to know, understand what easement is, know the characteristics, and then know examples of easement. And maybe in terms of like the legal basis, we have said that it is the common law which actually created this particular right. And the common law has done that by what you call like the prescription. That is the law which has actually prescribed or which resumes the grant of easement. Now, if we look at the Courts Act of 1993 at 459, you notice that we have a table of legislation which were statutes in general application that have remained in force. And one of such statute is what we call the Prescription Act of 1832. So the Prescription Act of 1832, which was originally an English legislation, by virtue of section 119 of the Courts Act, is applicable to Ghana. And what it seeks to do is to prevent a claim for an easement or profit from failure by proof that it had not yet been enjoyed from time immemorial, or that it came into existence sometime after 1189, which is used as the date for legal memory for English conveyancing purpose. So let us keep that in mind. Yeah, so these are some of the things that we should remember. Okay, questioner, I think this provides some guidance to you.
Yes, my lord, thank you. But then one last issue on the easement. Supposing the owner of the adjoining land or the nearby land is resistant, that when it is necessary for me to use it by all means, he's resistant. How can I can I go to court to demand it?
Yes, where the servient tenement, the owner of the servient tenement is interfering with your enjoyment of the easement. Yes, you can go to court, and then when you go and you're able to make a good case of the existence of that easement, that would be a clear case where, let's say, an injunction can even be given to restrain the proprietor of the servient tenement from interfering with your enjoyment of the easement as a proprietor of the dominant tenement. Yeah, I also mentioned that easement goes with the profit upfront, or some will say simply a profit. And as I told you, profit is basically the right to go onto the land of another person to take a particular type of object from that land, whether part of the soil or product of the soil. So if maybe you are going to take something from another person's land, that is a profit or profit apprend. But there are various categories of what we call the profit apprend, and these include profit appurtenant, profit in gross, profit appendant, and then a profit per course de vicinage. If you take like the profit appurtenant, for example, is a profit whether we are talking about several type of them or in common, which by the act of the parties, whether they have, they've actually done that or it is presumed, is annexed to some nearby dominant tenement and runs with it. So therefore, all the conditions which are needed for existence of a right as an easement must also be present for creation of a profit appurtenant to the land. So the only difference is that where in the case of easement, you are not going to take something from the land necessarily, but you are passing through, or something is being made to pass through the land of another person. in the case of the profit appurtenant, you are going to take something from another person's land. So let us keep that in mind. So that one will go hand in hand with like the easement. The easement will exist and then the profit appurtenant at the same time. Then we also have like the profit in gross. This type of profit is exercisable by the owner independently of his ownership of the land. That is the dominant tenement. In other words, the one who has a profit the profit in gross, is able to enjoy it, not because he is also the owner of the dominant tenement. As we saw in the case of easement, before you can enjoy the easement, which is carried by the servient tenement, you must be the owner of the dominant tenement. And the same thing applies with necessary modification to profit appurtenant. But then with profit in gross, the right which is enjoyed by the owner or the holder of the profit in gross is not dependent upon he also owning the dominant tenement, as it were. For example, if you have the right to take a fish from another person's fish pond without any restriction, that can exist as a profit in gross. So maybe let's say typically, let's suppose that there's a stream behind somebody's house and there were originally some fish in it, and then the person has also decided to develop it further into a fish pond. And people within the community or those around, they are also able to go there and take some of the fish, and the one who has made the fish pond cannot even restrict them in any way. That would be an example of the profit in gross, which we are talking about. But all these things, they are also affected by the Prescription Act of 1832, which you mentioned. That is to say that they are creation of the common law, and our laws have also recognized them through the Courts Act, as we have alluded to already. So the acquisition is very similar to easement by express grant, implied grant by necessity, and so on. So let's maybe like go to like the villages, for example. You see pawpaw, right? You see pawpaw or orange in somebody's farm. You can go and pluck some and eat, and the owner will not put up resistance because it is recognized as something which our law and also even their own customary system protects. That yes, for fruits growing in the wild, anybody who wants to help himself can actually go and take some as it were. So that is also some form of example of the profit upfront. Now, if you are asked to draw the differences and similarities between easement and profits, you should be able to do that. In terms of the differences, as we have stated not long ago, profits upfront differ from easements in the sense that profit upfront import the taking of something. That is, it has to do with taking something from another person's land, which is capable of ownership. That is from the servient tenement. But in the case of the easement, as you have noted, it's got nothing to do with taking, but just making use of the servient tenement in a way which will enable the dominant tenement to be enjoyed or useful. Okay. I think that should be some should bring some clarity to the question on the easement. Any other question? We are doing question and answer. So somebody has a question about the easement, and then we talk about it. So if you also have something which is bothering you, you bring it up and then we discuss it. Okay, if you have no questions, then 5 minutes,
No, my lord.
nothing comes, I will sign off.
No, my lord.
Yeah, Richard.
Yes, if nobody is coming, then I'll come with another one, please. Kelsen and Finney's theories, how we apply them in Ghana, please.
Which one?
Kelsen and Finney's, the two theories, how we apply them in Ghana.
Kelsen and
Finney's.
Kelsen and Finney's.
Yes.
But these are jurisprudence matters. Or Kelsen aspect of it applies to constitutional law.
That's my lord.
Yeah, okay. So you know that there is this theory called the effect of revolutions and coup d'etat on the pre-existing constitutional order, okay? Because we've witnessed coup d'etats and revolutions as part of our political history. Constitutional law in this country used to devote significant amount of energy and space to what we call the legal effects of coup d'etat on the pre-existing legal order. In other words, when people have used unconstitutional means, coup d'etat, revolution, so to speak, to overthrow the constitutional order, what legal effect does it produce on the legal order? Does it effectively destroy the entire legal order so that from the moment of the success of the coup d'etat into the future, everything legal or anything we call law must base itself on the authority of the coup makers or those who initiated the revolution before it will be regarded as having validity. So that is the issue, and it is within the context of that issue that we have a number of viewpoints, two main viewpoints, what we call the theory of continuity. We also have the theory of discontinuity. And those who advances the theory of continuity, we can, for example, see Hans Kelsen, his famous work, The General Theory of Law, when the pure theory of law, when he advocated that if you take any legal order, all the rules within the legal order, they derive their validity from each succeeding legal order. Because in his view, the legal order is like an inverted pyramid. You know how pyramid is. You know, pyramid has got like the apex, like the pointed end towards the sky. But he used it in the reverse. That is like the pyramid is turned so that the apex, if you like, is like the bottom. And all legal rules. They derive their ultimate authority from the apex. That is they invented the pyramid. That is where the main rule is, and you call that like the grun norm. The grun norm, that is the most primary norm, and that primary norm gives legal effect or validity to all other succeeding norms. And for that matter, Kelsen will say that when a coup d'etat has occurred, the legal order which existed before the coup d'etat are effectively swept away. And from that moment onwards, legal validity is referable to the authority of the one who succeeded in making the coup or the revolution. And that is what they call like the grun norm, like the most basic or the primary norm. So therefore, if in Ghana, remember like the famous Salah case, when during the Second Republic, I think there was an attempt to change some public or remove some public officers from office, and it was no challenge, and the court had to discuss the effect of the coup d'etat, which was made, that swept away the Republican constitution and its effect on this new regime and all that. Yeah, so you all know the Salah's case. I mean, every student of constitutional law knows Salah's case, so I did not belabor that point. And if you like cases which are similar to Sarah, which are also used in discussing the theory of discontinuity, then you look at the case of Michel versus DPP, right? Michel versus DPP. And also look at the case of Mazimabuto versus Lagnabek. And then the case of Espati Matovo. All these cases are similar to Salah's case. And yeah, then we also have the theory of continuity. Those who hold the view that it is a fallacy for anyone to postulate the argument that when there has been a successful coup d'etat, the entire pre-existing legal order is swept away. Now, the continuity school of thought says that that is not true, that the pre-existing legal order continues. And they will point to, for example, the court structure, right? The judicial institutions which were in force. And you say that if you look at all the instances you have coup d'etats, it's essentially those who control the executive, and probably like the aspect of like the legislature, which will be swept away. But some aspects of the legal system and then the legal order remain more or less intact. And for that matter, it is untenable to say that the effect of a coup d'etat is to actually sweep away a pre-existing legal order. So you mentioned like the Finis. Finis is a natural law scholar, and I don't want to say that because he's a natural law scholar, that is why he subscribes to the view of continuity. Because otherwise, if we take H.L.A. Hart in his concept of law, when he discusses his famous primary rules and the secondary rules, he will develop the point that the legal system is made up of various things, and for that matter, you can always see the element of continuity. And it is not right to actually hold the view that when we have some revolution or some uprising or some other unconstitutional means of changing authority, it will affect the continuity of the legal system. Yeah, so I think these are some of the things which I think are relevant. Richard? Richard, you asked a question, isn't it? Okay, if he's sleeping. Yeah, any other question before I sign off?
Hello, sir.
Yeah, Vincent.
Thank you, sir. Sir, recently we heard that Parliament had amended parts of the law regarding death penalty, especially in respect of the code, our criminal code. I also know that as part of the constitutional provisions, especially regarding the fundamental human rights, and even if you look at Article 3.2 and all of that, where a person who commits high treason upon conviction shall be sentenced to suffer death. I thought that these are entrenched provisions, for which reason, if we had to amend them, we would have to undergo what the Constitution has provided for. So I am quite confused about how Parliament was able to do it through, or able to abolish the death sentence through the criminal code, and what it really affects, whether it affects what is in the Constitution or not. Thank you.
Right, thank you very much. That's another equally good question. Yes, you are right. The aspect of the Constitution which says that if you attempt to overthrow the Constitution or you engage in any treasonable acts and you are found guilty, you have to suffer the death penalty. That provision, as you rightly said, is entrenched. And again, you're also right that the bill relates to the Criminal Offences Act and then the Criminal Procedure Act, as it were. So therefore, where someone has committed murder and our law says that he should suffer death, I think that is something which Parliament can easily amend, because it is not the Constitution which says that if you murder someone, you should suffer the death penalty. But where the Constitution says that if someone commits treason, high treason, the person should suffer a death penalty. That aspect cannot be amended by Parliament unless Parliament engages the amendment procedure for entrenched provision of the Constitution. But an argument will be made that the fact that that bill, if it has been passed at all, the fact that that bill has been passed is an indication on the part of the lawmakers of the country to outlaw or to scrap death penalty. And if we still have some death penalty in our law, it's just because of some procedural complexity, such as you need to go through referendum and all that. And that is why we have. But at least the fact that they've been able to amend the death penalty, which is founded upon just an act of Parliament, is a clear indication of what the intention of the lawmaker is if they get the necessary opportunity to amend the Constitution. Right? Okay, any other? All right, thank you. Any other? Otherwise, I'm signing off. Okay, let me see the chat. There. Somebody is asking a question. That, let me see. Where the president wait to issue a white paper at the 5th month regarding report or commission of inquiry. Would that mean that the white paper becomes judgment of the High Court after 11 months after the report is submitted? Okay, so the person is interested in the commission of inquiry, chapter 23 of the Constitution. And just let me remind you that I have done a full discussion or a full lecture on commission of inquiry, not this year, but I think sometime last year. And the recording is available. And because the recording is available, as I keep telling you, that is why I avoid repeating a whole lesson on topics. But in case you are interested in knowing more about commission of inquiry, in addition to reading the constitutional provision and also the CI, which was passed to govern the procedure of commission of inquiry, I also encourage you to look at the lecture that I gave. But coming back to your question, if you look at Article 280, right, clause 5 of the, or maybe let's even start from clause 3, which says that where, maybe you can even go to 2, so that we get like the full picture well. That where a commission of inquiry makes adverse finding against any person, the report of the commission of inquiry shall, for purpose of this constitution, be deemed to be the judgment of the High Court, and accordingly, an appeal shall lie as of right from the finding of the commission to the Court of Appeal. So that is the starting position, that an adverse finding, that is a negative conclusion is made on you regarding the matters the commission of inquiry inquired into, that will operate as a judgment for you. However, we are told in Article 280, clause 3, that the president shall, subject to clause 4, cause to be published the report of the commission of inquiry together with the white paper on it within 6 months after the date of the submission of the report by the commission. And this is where our friend's question comes in, that if the president waits to issue the white paper at the 5th month, and then the provision says that within 6 months. So if the report was issued at the 5th month, it's still within the time. But we look at the clause 4, that where the report of the commission of inquiry is not to be published, the president shall issue a statement to that effect, giving the reasons why the report is not to be published. However, we have some parameters where the commission of inquiry's finding, even if it is an adverse, will not operate as a judgment of the High Court unless certain strict conditions are fulfilled. And we see this in Article 280, clause 5, that 1, 6 months have passed after the finding is made and announced to the public, or B, the government issues a statement in the Gazette and in the national media that it does not intend to issue a white paper on the report of the commission, whichever is the earlier. So any of the following, any of these two that we have mentioned should occur. Otherwise, the judgment, the adverse finding will not operate as a judgment of the High Court, which can be appealed, as we have looked at not long ago. And then finally, if we look at the clause 6 of Article 280, that the right of appeal conferred on a person against whom a finding has been made shall be exercisable within 3 months after the occurrence of either of the events. So we talk about two events: either you publish a white paper, or 6 months elapse, you don't publish the white paper, or you even make announcement in the Gazette that the government does not intend to issue a white paper. Where that is the case, then within 3 months from the elapsing of the 6 months, or within 3 months from the publication in the Gazette, the government does not intend to issue a white paper. If an adverse finding was made against you, in which case it operates as a judgment of the High Court, you are entitled to appeal if you want to challenge that in the Court of Appeal. Now, the question which we have in the chart says that where the president wait to issue a white paper at the 5th month regarding report to Commission of Inquiry, would that mean that the white paper becomes judgment of the High Court after 11th month after the report is submitted? No. You see, it is not the white paper which is the judgment of, or operating as judgment of the High Court. It is the Commission of Inquiry's report, right? All that the white paper will do is to state the government position on the conclusion by the Commission of Inquiry. But if, let's say, the adverse finding was made against you, the government has issued the white paper, but the government white paper is silent on the aspects in which adverse finding have been made against you, you still have the report of the commission standing as a judgment against you. And if you don't appeal it, it can have consequences on you in the foreseeable future. Kojo, I don't know whether that assists you. Otherwise, you can explain what you have in mind. Okay, the questioner is even not here. Okay, all right. Any other? Otherwise, we are ending now. Okay, then have a good night.